Hey, aloha, Hawaii Volcano Squad. This is kind of like an emergency uh, Second Amendment victory announcement because how often does a judge get a court clerk to come in and file important Second Amendment case rulings on a Saturday? I mean, everybody just missed it this weekend. I mean, nobody files on a Saturday. It's always Monday through Friday. So here, first thing you got to look at is this district court, District of Columbia, uh, and the date. I want you to notice the date on this screen share document I have up. And it's August, this is a document from the court, filed August 6th, 2009. Palmer versus the District of Columbia. 2009. And Saturday there was a decision. And here's the thing. Now, I live in the state of Hawaii, and there's only really one Second Amendment site in the state of Hawaii. And I got flamed and griefed or whatever they call griefing or whatever on there. And I left. I don't go back because I said, we need to file a writ of mandamus against people who are intentionally just subrogating the court rulings, the Constitution. Anyway, they basically, it's like, only the people that won the Baker case know what they're talking about. You don't know what you're talking about. You're not a lawyer, and I'm not a lawyer. Just shut up, and if you want to help, give them money for lawyers. You couldn't possibly have any good ideas. After all, what do I know? So they're saying a writ of mandamus is completely useless for Second Amendment cases. Well, I guess they don't know what they're talking about. So here was the August 6, 2009 ruling. So I'm not going back to that site. Just too much yelling and arguing and flaming, and I don't need it. I'd rather just go to the range and take in some nice, friendly target practice. Anyway, so August 6, 2009, Palmer versus District of Columbia was filed. Now, first, the next thing that happened after the case was presented is nothing. And I do mean nothing. And let me go to another screen share. Hang on. This wonderful thing we call the internet. Let me pick another file to the next important case. Alright. Stand by while I push all the right fucking buttons. Oops, damn, sorry. Sorry, I apologize for the curse word. But this is a late night emergency. Alright, let's hit the screen share button again. Gotta push too many buttons. Okay, all you people that said a writ of mandamus doesn't do any good. On a petition for a writ of mandamus to the United States District Court for the District of Columbia, filed October 21, 2013. So, 4 years after the case was filed. This judge didn't want to make a ruling. It says so. Let me scroll down this court filing here. Hope you're getting all this, guys. Relief sought. Respectfully petition the court to issue writ of mandamus in aid of its appellate jurisdiction directing the United States District Court for the District of Columbia to decide forthwith, within 7 days, I'm going to mispronounce dispositive. Damn lawyers. dispositive. There it is, dispositive. That's a legal word. Basically, it means the defendant filed a motion for summary judgment, and that's the District of Columbia, and Palmer filed a motion for summary judgment. So they're cross motions. They say rule for us, and the other side says no, rule for us, and end this. Cross dispositive motions. What kind of a word is that? Basically, they just filed for summary judgments. Anyway, why don't they just say that? Both sides filed for summary judgments, cross dispositive motions. I guess you learn that crap in law school. Anyway, it's a good thing I didn't go. Let's see, petitioners do not lightly, blah, blah, blah. We may discuss some of the other cases. So basically what this case was about was some guy driving through D.C. got pulled over on a traffic stop. He was never issued a traffic ticket, and there was a gun in his car, and it was loaded. We had permits, but not in D.C. because they don't issue permits. He was just driving through, and so they sentenced him to like a year probation or something, and he took the case to court. Says he didn't do anything wrong, and let's see, Heller, and they decide all the cases that have been ruled on since the case was filed. I'm going to have to say that word a couple of times, cross dispositive motions. Anyway, so this here's the entire reasons why here's the entire writ of mandamus, reasons why the writ should issue. In aid of its appellate jurisdiction, the court is empowered to compel the district court to decide excessively delayed cases. So, again, this is in May of last year. So, let's see, blah, blah, blah. Petitioners are entitled to relief under the general mandamus status. Now, if you don't know what a writ of mandamus is, that is a writ that compels a public official to do something that he should be doing to fulfill his role as a public official, but he isn't doing it. So you can push. It's basically you can force somebody to do something, a public official who's not carrying out his duty. The delay in resolving this case is manifestly unreasonable. There it is. And lots of precedents, lots of precedents. So here's this entire precedent of this case, all the precedents he cites. And you know what the judge ruled? In that May, basically it was just a one text line that said, text order denying motion to strike supplemental memorandum. It is so ordered by Judge Frederick Scullin. So they denied the writ of mandamus. Now let's fast forward. The next follow-up writ of mandamus, which was filed on, as you can see in a moment, as I push the right freaking button. Start screen share. May 6th, 2014. I mean, and this is on a 2009 case. That's just nothing happened on it. The arguments were presented. They went to court, and both sides asked for summary judgment. And so May 6th, they filed again, another follow-up writ of mandamus. They didn't originally, deny them the right to file again at a later date. Renewal of petition for writ of mandamus. And this is specifically what everybody in the Hawaii Second Amendment side said, oh, it can't be, you can't, this doesn't make any sense in a Second Amendment case. Nobody uses a writ of mandamus. So, obviously, since the case was filed, there have been a lot of pro-Second Amendment rulings in circuit court. Heller, McDonald, Karuta. Which still hasn't been finalized. Here they're citing Karuta. It thus appears difficult for commentators to shake the suspicion that delay extending well beyond normal for any kind of case, let alone a factually disputed priority civil rights case, is calculated. Dragging out the case appears to be a deliberate attempt by lower courts to leave intact this infringement on a fundamental right. Emily Miller, justice delayed is justice denied. Right. Justice delayed is justice denied. Well, I mean, the sad fact of this ruling, this is funny. Judge Scullin apparently has no desire to rule on what would obviously be another high-profile case involving that inconvenient, embarrassing Second Amendment. So they're saying they have no fair access to the court if the judge doesn't want to rule. There may as not. I mean, one way or the other, there may as well not be a court if he never wants to issue a ruling. So basically, they filed the case in 2009, and nothing happened after they filed it. They didn't rule against him, and they didn't rule for him. They just didn't do anything. He just sat on it. I mean, since 2009, he sat on it. Justice delayed is justice denied indeed. Petitioners paid their filing fee. They have followed all the relevant deadlines and done what they're supposed to do. They are entitled to a decision in this case. And so as a public, it is fundamentally unfair to ask that they continue waiting for that decision in absence of a writ of mandamus. Wish we could get that in Peruta. I'll talk about the state of Hawaii a little more after I get to the ruling, which is a good one for if you like the Second Amendment and the 14th Amendment, the Constitution, or just like gun rights in general. Yeah, sorry for the delay while I punch up these rulings and stuff, but I'm no computer genius here. You find the dang ruling. Try and get it all up here. So this is like a late night Saturday, and they forgot to tell anybody. It's like a sneak ruling. I mean, he got this in while there's a war everywhere, so maybe nobody will bother to notice it or something, because you got UN problems all in the entire Middle East and Ukraine and everything. It's just all messed up, and the UN telling people all kinds of stuff that they should do. Let's see if I don't want to make this font too small. All right. It's always hard to press the right freaking button when you need to. Start screen share. All right. So we're talking, this filed 7/26, the court ruling of 2014 on a case originally filed in 2009. Senior Judge Scullin. Currently before the court are plaintiff's motions for summary judgment and defendant's cross motion for summary judgment. Let's see. In their complaint, they assert two claims for relief. Plaintiffs allege that by requiring a permit to carry a handgun in public, but refusing to issue such permits and refusing to allow the possession of any handgun that would be carried in public, defendants maintain a complete ban on the carrying of handguns in public by almost all individuals. Plaintiffs also contend that defendants' laws, customs, practices, and policies generally banning the carrying of handguns in public violate the Second Amendment to the Constitution facially, it's called prima facially, he didn't even write it right, as applied against the individual plaintiffs in this action, damaging plaintiffs in violation. In the second claim, plaintiffs allege defendants' law, custom, practice, and policies, generally refusing the registration of firearms by individuals who live outside the District of Columbia, violate their rights to travel and equal protection secured by the Due Process Clause of the Fifth Amendment to the United States to the Constitution. Blah, blah, blah. Legalese, mumbo jumbo. Plaintiffs seek relief in the form of an order permanently enjoining the defendants, their officers, agents, service employees, and all persons in active concert or petition participation with them. God, I'm almost as bad as Senator Schatz. Anyway, I'll get on to that later. From enforcing D.C. code to ban registration of handguns to be carried for self-defense by law-abiding citizens. Wherefore, whereas, blah, blah. More legalese, mumbo jumbo. So let's get to the ruling. I don't want to bore you with all the stuff, how DC says you can't carry stuff. Discussion, he mentions, okay, District of Columbia versus Heller. 2 years later, McDonald versus Chicago, Illinois. Cites the Peruta case. Hey, I know this isn't as fun as like a shooting at the range commercial, but if you want to go for video, or an ammo porn video, but if you want to actually follow what's happening in the court and protect your rights, don't vote for somebody like Senator Schatz of Hawaii. And read this stuff. Let's see. Going as fast as I can. I know you guys like videos under 5 minutes, but this isn't going to be one of them. The Second Amendment courtroom stuff is tedious, but it's important. So this is, they have the whole Heller, the right exists outside the home issue, where the state of Hawaii lawyer in Baker argued that the state of the right to carry and defend oneself with a firearm stops outside the home as soon as you leave your door, because if the criminal knows the victim has a gun, then the criminal will always come with a gun. And to which the Peruta judge said, the Baker judge said, Baker case, but we don't issue permits to criminals. And the entire courtroom erupted in laughter because it's such a baloney argument. You can't carry a gun because your attacker will have to carry a gun if you do. I mean, that's just dumb. So where's the hell? Are we getting down to the ruling yet? Come on, guys. Equal protection and the right to travel challenge to residency requirements. District of Columbia is so small, if you get on the freeway driving through it, you get pulled over for a traffic ticket. You need to have a permit just driving through it. Having reviewed, conclusion, thank the Lord, having reviewed the party submissions and the applicable law, and for the above stated reason, the court hereby grants plaintiff's motion for summary judgment and denies defendant's cross motion for summary judgment. The court further orders that defendants, their officers, agents, servants, employees, and all, basically everybody who receive actual notice of this memorandum decision order are permanently enjoined from enforcing D.C. code, and they cite the number, to ban registration of handguns to be carried in public for self-defense by law-abiding citizens. And the court further orders that defendants, officers, and their dogs who receive actual notice are permanently enjoined from enforcing D.C. code, another number. Orders the defendants and their officers, agents, employees, and dogs and cats in active concert or participation with them receive actual notice of this memorandum from enforcing another 2 D.C. codes based solely on the fact that they are not residents in the District of Columbia. Right. Signed, Frederick J. Scullin, Senior United States District Court Judge. This is a district court ruling, and basically the writ of mandamus was in the Federal Circuit Appeals Court. And that's pretty good news. So, probably at this hour, nobody's on. I'm going to take a quick look, but yep, nobody's up. Everybody's asleep. It's not that late in Hawaii, guys, but it is everywhere else. So what? Well, probably what will happen. There's two possibilities. They'll appeal it to the Federal Appeals Court, and they like simple cases, so they'll appeal it, and during the appeal, they'll probably change one letter of the law or take out, a step, or, they'll change the law a little bit, and then claim it doesn't do what they'll try and restart the whole process down to the lower court. First, they'll appeal it just to delay. It's delay stall, and this is where I'm coming from. It's like we need to just, we're reaching the point in that the states have, all the states, anti-gun states, politicians have developed this technique of passing unconstitutional laws, and there's no penalty for it. But except they're doing it to deny people constitutional rights. So we need to have, if there's no penalty for it, then we need to use these writ of mandamus in the broadest possible sense to stop this crap. I mean, if they can force a judge to issue a ruling that he doesn't want to issue, he didn't want to write that ruling, but he knew what the law was, and he just followed it, saying those laws, all those D.C. carry laws are unconstitutional. So it's like, if you can force a judge to do it, you can sure as heck enforce, a governor, or a legislature, or a sheriff, or a mayor, or a police chief, or a firearms clerk, or anybody. If they can force a judge to issue a ruling that he doesn't want to issue, why not just a writ of mandamus against the whole state? Maybe some lawyer, if what they're doing is, ignoring the court's rulings and the Constitution by a process which is, delay, change the law, reboot the court. There's no penalty for, passing unconstitutional laws. So in the state of Hawaii, I'll say a word about Senator Schatz. So I think it was a Kaka or something that retired and or died or something. Anyway, and Schatz was appointed by the governor, the Democrat, and so he has to run for office, and this guy is very young. And he's been putting out now, since he has to run for election. First thing he did was say how great he was on dealing with being the chairman of the tourism the Senate Committee on Tourism, and he's only the chairman because he took over for the guy who was the chairman. He's a straight backbencher. This kid's young. He doesn't know anything. And I actually watched the Tourism Committee on C-SPAN, and basically this guy was reading from a speech. The words, the cross dispositive that I was stumbling over? Well, this is how the meeting went. A senator meeting, the Tourism Commission for the United States Senate, promoting tourism and stuff. And you can see how a senior senator from Hawaii would be in charge of it. Everybody likes to visit Hawaii from all around the world. And my God, he had this statement in front of him, and he didn't deviate from it. And when he got to a hard word, every hard word, he would mispronounce it, go another 3 words forward, and then he'd realize that he'd mispronounced it, and then he'd go back. And when he got to a hard word, he couldn't read it. Now, I've never seen the word dispositive before because I'm not a lawyer. I mean, have you ever used that word in a sentence? Cross dispositive? No, but there was a lot easier words than that aren't legal words, and he just stumbled over every hard word in his statement. And so it was really funny because the witnesses, there's a panel of senators, he's the chairman because the guy who he took over from was the chairman. Nobody would make some young kid like this Mr. Smith goes to Washington. I mean, But so anyway, then he comes on with all these, I want to ban assault weapons. I want to close the gun show loophole. And my God, because the election's close, I mean, you can't turn on the TV on any channel without, the Democratic Party is just. I mean, we only have 2 Democratic, I think, because it was a Democratic seat. This is a one-party state communist system here. It's like we were fighting communism in the Soviet Union, in the Cold War. We always used to say, oh, it's a one-party system. It can't work. Well, guess what? State of Hawaii is a one-party system. You got 1 Democrat or 1 Republican in the state Senate, and that's it. And he loses every vote 27-1 or something like that. Anyway, so this guy, he has a picture, he has a video with his family and his kids, and he just sits there, stands with, I want to make Hawaii safe for doing this for my kids. I want to ban assault weapons, and he's a joke. I want to do it, and he looks right into the camera with that smile, because if you have to, but let's get back to the tourism meeting. So he's reading his statements. When he gets done reading his statements, and he doesn't add anything to it, he doesn't have any comments of his own. It was written to him by the staff, formed by the staff of the former senator. Then the witnesses, they read their statements. It's not even a conversation. One senator's staff reads something, the other then the agency guy's staff reads what the lawyers for the agency wrote for him to say. Nobody asked any questions. Nothing got done at this meeting. I mean, if there was any backroom deals to get, he was boasting that he got United. They were going to outsource 200 jobs in Hawaii from United Airlines or something, and that was just because he was the chairman of, he could cause problems. They greased a wheel. That's how Washington works. But so. And I'm just not really sure how far we can go. When you turn on the TV and there's every show, there's an anti-gun gun control. This guy saying he wants to, ban assault weapons and guns to make sure his kids are safe in the future. I mean, nobody uses assault weapons, whatever they are, to commit crimes. I mean, around here, it's. I mean, even in Honolulu, I think somebody used a .22 rifle once to hold up some Denny's, but they wouldn't even try that if people had carry permits, But mostly it's just blunt instruments, and so like there was the attack a month or 2 ago by the Denny's on my block, and then just a block away there was the dead guy they found under the Kona Pier. Right by where the governor is having his next forum, I submitted a question to the forum, governor's candidates forum, and they're both Democrats. Abercrombie, he's a pretty smart guy. He knows the state of Hawaii very well, but he's part of that Second Amendment ban cabal. Anyway, so this is, it's a good ruling. This decision, Palmer versus DC, but I don't think anything's going to change. I mean, yeah, they can't enforce that law, but they'll just change it and say it's different, move some commas around or something. And And they'll appeal it, they'll change it, they'll delay it, they'll stall it, and then when it gets struck down, they'll pass a new law that kind of does the same thing, even though it's worded differently. And that's why we need to be able to file writ of mandamus against an entire state for just, doing this. It's called abuse of process. And of course, proving that the entire state, the legislature, governor, and the police chiefs and mayors are abusing the process, you know, by rendering the courts completely irrelevant. It's called abuse of process, and that's a legal term for it. And I didn't go to law school, but that is a legal term. So that's about my rant for today. So basically, I submitted my question to the governor's debate in Waimea, and they're having a debate Tuesday in Icona, right by where right at where the dead guy was, 52-year-old guy was found, or at least near death, and they medevaced him, and they pronounced him dead when they got to Honolulu. But and he just was hit with some kind of blunt instrument, and he couldn't. Nobody caught that criminal's still at large. Nobody caught who did it because he didn't live to tell his story of what happened. Just a dead guy into the pier. But he would have liked to have some way to defend himself. But so they're going to have this debate. I think you have to register to go. And I mean, I sent the question people my questions, but that's not the kind of questions they ask. When you gonna stop, substituting your judgment and follow the court ruling for the Constitution, the founding fathers, and follow the court rulings, and Heller, McDonald, Baker, and Peruta. And probably the answer would be when hell freezes over is when they're going to do that. So that's why I'm just saying, these people, who just want to win one case and jump up and down, they're ignoring the fact that the entire system is being gamed, and that's why you need a writ of mandamus to stop them from doing that, and to make them, stop rendering the courts meaningless. I mean, you could win every Second Amendment case, but if the entire state has determined that they're going to use every means to ignore the rulings, what was that when there was a famous quote that probably Andrew Jackson didn't actually make or was misinterpreted, but the principle kind of illustrates what I'm talking about. In the Indian cases about the Trail of Tears, when the Supreme Court, basically, said you can't just, it was a Cherokee Nation versus a state of Georgia, and at first they ruled against the Indians, and then when they actually moved some white people off the land, and they reversed their ruling, and they basically couldn't repossess. That was the case where Georgia just had a lottery, gave away all the Indians' land, the Cherokee tribe, and force marched them through the land. Of course, it belonged to somebody else, and they had to kick them off during, when they. So basically, the court reversed their decision and said, okay, you can't do that. And then Andrew Jackson, the famous quote, which probably isn't correct, but the principle again is right. It was like, okay, the Supreme Court made this ruling, let them enforce it. The executive branch is supposed to enforce the court rulings, and if they are determined to not, as a matter of fact, if your whole legislature, executive, mayors, and everybody in the entire state doesn't want to enforce the court rulings, then that's what I think a writ of mandamus is for. And if they don't do it, then they're criminally and civilly liable. But that would actually take some incredible lawyer who can do more than just win a case and can think for himself. And I don't think there's any lawyer like that out here who's that good. And especially the people who've won all these Second Amendment cases, I don't think they're that good to do that. Although here's a an example of a writ of mandamus being actually used in a Second Amendment case, which people on the 2A Hawaii site were saying, no, you don't know what you're talking about. You can't use a writ of mandamus in a Second Amendment case. Well, they got a judge to issue a ruling that he didn't want to issue for the writ of mandamus. It took 2 writ of mandamus. But, like I said, the entire process is almost meaningless because if the state is determined to ignore the court's rulings, then, by gaming the system, by, like I said, they change a word, they appeal it, just kill the clock, and then they, it's like garbage time. It's watching all these cases. A lot of it's like I'm wondering if it's just like watching garbage time in the basketball game after it's already over. I mean, it's over at the election, basically. What was that quote by? Was it Voltaire? Somebody said, the people are only free. He's talking about the people of England. The people of England think they're free, but they're wrong. They only have every 4 years they're free for 5 minutes inside the voting booth, and they make such terrible use of that 5 minutes that they deserve to lose their freedom for the next 4 years. And that's basically what the problem is. When we here in Hawaii live in a one party state, it's not a communist party, it's a democratic party, but it may as well be any one party system. It's like how you put it in Hawaii terms. It's like what you should be doing is rotating crops. If you plant corn every year in the same parcel, eventually the soil is just not going to work for you. You're going to have crappier and crappier corn, and even GMO won't be able to save you. But if you rotate your crop rotation, and leave it, don't farm it, one season, and the next season plant something else, then you won't have, it's the same problem. But if all we get is Democrats, and the Democratic Party they're throwing it. I mean, it's on the Senator Schatz guy is on his anti-gun commercials are on, vote for me and I'll ban guns. It's on every fucking channel every fucking day. God damn that motherfucker. Anyway, so I think that pretty much closes out the rant. How long has this damn thing gone on for anyway? My God. Too long. Let's see. I don't know. Well, that closes out the rant. Yay! But we did win that ruling in Palmer versus the District of Columbia. I got to use the sound effect button once. Alright, guys. Aloha from the state of Hawaii.